With respect to the Bill of Rights as a robust protection against abuse of the commerce power, I think we should just look at what is at issue in this case. What you all are saying is that requiring people to carry a minimum level of health insurance under current circumstances and within the context of this statute and the other laws that we have governing the delivery of health care, that is essentially a horrible invasion of individual liberty. I think what I'm trying to say is that under existing law, we have a framework for evaluating that claim. It's a perfectly sensible framework. And when you put a spotlight on the nature of this liberty interest, as Walter has explained in some detail, it shrivels as an important liberty interest. It couldn't possibly qualify as a fundamental liberty interest or a fundamental personal liberty right, and it shouldn't. And again, I paid reference to what Governor Romney said. So I think that if you use the existing framework for balancing an asserted liberty interest against Congress's exercise of the commerce power, it would be a perfectly sensible framework. It would result in a clear ruling that this liberty interest doesn't measure up to what it takes to defeat a rational exercise of Congress's authority. So here we are, the people challenging the mandate are trying to work a radical change in existing law, and one that really isn't necessary and isn't a very good one. I'd like to just mention a couple of one other point, and that is we need to think about what the consequences of accepting this radical change in the Constitution could be for other laws and programs that are terribly important. And just to deal with it on a stratospheric level, basically reading the necessary and proper clause out of the Constitution as an independent source of congressional authority would have consequences that are really quite incalculable, because that hasn't been the law for 200 years. And there aren't any close cases that we could identify that would go the other way. But it wouldn't take conservative or libertarian legal advocates as clever as the ones seated strangely to my left.
They are stage right.
Stage right. Well, there's that, to your right. It wouldn't take them a great deal of time to figure out some very intriguing cases to bring, challenging all sorts of laws, I'm sure. So the necessary and proper clause point of the opponents would very likely trigger an explosive set of challenges to major existing programs.